What someone's status in the US is under immigration law could affect many other areas of the law. For example, the first bullet point in the slide before you talks about the capacity to contract. I noted earlier that non-immigrant visas typically are limited to a certain purpose. If a person enters into a contract that is in violation of their status, is such a contract enforceable by that person? Arguably, would public policy not prevent enforcement of such a contract? Right now, I don't know of any judicial precedent that says, yes, that's the way it is, or no, that's not the way it is. But think about it. Let's say somebody enters USA to study. F1 visa. It is restricted to studying and under very limited circumstances, certain kinds of work. This person then hits upon a brilliant idea and gets together with somebody else, and they start developing a product, maybe a software of some kind. And tomorrow they want to go to court over it. Really, the student was not authorized to be working on that. Can this contract be enforced? I don't know. Something to look at. Okay. Another thing, and I don't have it in the bullet points, but it's in my mind, that when you litigate against a company that is heavily invested in immigration, it would be quite interesting to start looking at their immigration files, whether in discovery or even under general laws, immigration laws. Employers are required to maintain certain information, and it can be quite extensive, for public inspection. Look into that. Sometimes you might be able to get to issues that are not necessarily, you don't have to go into discovery. Any John Q. Public can walk in and say, show me these public disclosure files. Keep that in mind. I have a bullet point on the right to stay in USA. So non-immigrant visas limit not only the purpose, but also the duration of a person's stay. In litigation, this comes up quite often. So a foreign citizen wants to stay in USA and litigate a claim such as domestic relations. But maybe he's not allowed to, or she's not allowed to. That happens. So what do you do in cases like that? Well, that's where you get yourself an immigration practitioner, sit with them. Maybe there are certain things you can do. We have helped in areas like this. And sometimes it's not possible to do anything, but many times we can do some things about it. In criminal defense, we have seen more claims of ineffective assistance of counsel because the lawyers did not know the impact of a criminal plea on immigration status than in any other area of the law. So criminal defense counsel right now I think at this stage of learning, almost everybody is aware of this problem. But a few years ago, we saw a spate of malpractice claims or ineffective assistance of counsel claims against criminal defense counsel. What happens is that immigration rules are very counterintuitive. For example, conviction under state law, deferred adjudication, some of these devices where you are not actually convicted. You agree to certain kind of pleas, but you're not yet convicted. However, under immigration law, that might be a conviction. Bear in mind a few things. Is it a conviction under immigration law, even though you don't consider it to be a conviction? I had a Pennsylvania case a few months ago where counsel was so convinced that this was not a problem until I showed them the way they were thinking was going to create a problem for their client. because as part of that diversion, I forget the name of the program, I think it was some kind of diversion. As part of a diversion, they had to plead certain elements that would amount to a confession under immigration law. So you cannot assume that just because it is not a conviction under your state law, it is also not a conviction under immigration law. Why are we so worried? Because immigration law convictions, you could end up barring somebody from entering USA forever. Aggravated felony crimes, for example. And what is an aggravated felony? That's another area of the law that's rapidly and forever expanding. Okay, is the crime a crime of moral turpitude? They have certain implications, certain things that you need to worry about. So is it covered by something called a petty offense exception, which means a one-time misdemeanor in somebody's life? What is misdemeanor? There are some things called, and over a period of time I've learned more about this than I really wanted to, but I had to. There are some things called aggravated misdemeanors, which the state calls it a misdemeanor, but under federal law, immigration law, that becomes a felony. Okay, so be careful and be mindful that the definition of the same things that you consider to be common sense and common knowledge under your area of the law could be radically different under immigration law.